Across Nigeria, thousands of citizens live and work outside their states of origin. But for many of them, especially those in government service, being a non-indigene can come with serious challenges, from denied promotions and job opportunities to outright dismissal. The issue stems from a system where states often favor indigenes, those originally from the area, in public appointment, benefits, and contracts. A recent ruling by the National Industrial Court in Port Harcourt overturned the 2011 dismissal of Mrs. Anikwendu from Abia Civil Service for being a non-indigene, declaring it unconstitutional under Section 42. The court ordered her reinstatement with full pay.
The indigene and non-indigene issue is anti-development, it's anti-unity, because it runs contrary to what the Constitution says. The non-indigene and indigene policy as instituted by some state governments, to me, is like the biblical saying of every man to your own tent, and every person trying to be an island to himself. It doesn't contribute anything positively towards national unity or national integration. Rather, it is divisive and destructive, and sows mutual disrespect and mutual suspicion and hatred. Now, on the issue of the lady who was sacked by Abia State government in 2011, and the judgment by the Industrial Court in Port Harcourt, for me, is very, very positive and progressive, and it is to show that our judiciary and our court, they are functioning very well, just as they functioned. They got it right in delivering this judgment. It remains the refuge where the common person can go and seek redress for any injustice done to him or her as a Nigerian citizen. I remember that Section 42 of Nigerian Constitution, which is the Supreme Constitution that overrides any other policies or laws, Section 42 grants every Nigerian equal rights to do everything that is legally acceptable and anything that not run contrary to the Constitution. So people now coming to impose indigene or non-indigene policies is contrary and an affront, direct affront to our Constitution, and it will take us to nowhere. It will rather make us to be moving in circles, and we'll be just talking about unity as rhetorics. For instance, look at the wordings of our national anthem, the first and the second. Unity is central, but when it comes to doing things that will bring us together politically, mostly politically, because this is a politics, they will begin to do the right opposite. So the indigene and non-indigene policy for me is an issue even the Supreme Court, the Apex Court, should proscribe outrightly. And any government or any state House of Assembly that endorses that should be penalized.
Also, Section 41 guarantees every Nigerian the right to live and work in any part of the country. Despite these laws, many states still operate in ways that marginalize non-indigenes, limiting access to jobs, scholarship, and social programs. Legal experts say this practice undermines national unity and principle of equal citizenship.
The court was very, very correct by cancelling and declaring that termination null and void, and ordering the reinstatement of Mrs. Anikwendu because she was unlawfully, illegitimately, and unconstitutionally dismissed from the services of the state government. Basically, not because of her misconduct, not because of her inefficiency or incompetence, not because of any administrative infraction, and not because of any other illegal act committed by the civil servant, but simply and essentially because of the fact that she did not originate from the state. A state that is a part and parcel of Nigeria, and every component federating state in Nigeria is expected to be guided by the constitution of the country, which is the ground norm and the primus law and the primus body of laws of Nigeria. And any law, any administrative action that are inconsistent with the provisions of the Constitution shall be declared null and void to the extent of its inconsistency. The administrative action of the government that dismissed that official, Mrs. Anikwendu, on the basis of her origin, on the basis of her state of origin, had run foul of the provisions of the Constitution, especially at Section 42 of the 1999 Constitution as amended, which provides that no Nigerian shall be discriminated against on the basis of ethnicity, on the basis of origin, on the basis of gender, and on the basis of who the person is. So such action that terminated her appointment was declared null and void because it runs counter to the provisions of Section 42 of Nigerian Constitution. So the court was completely correct.
Over the years, national conferences and federal administration have called for the abolition of indigene and non-indigene divide, but enforcement remains weak.
In terms of reforms at the state level, I know that the present administration of Alex Otti, the templates that he has put in place ensures that Nigerian unity is seamlessly promoted. For instance, the person who is the head of service of Abia State is a non-indigene, somebody from Edo. And the interesting thing was, this person came to Abia State in 1999 as a youth corper and distinguished himself and later was employed and has risen through the ranks until 2023 when he was appointed a permanent secretary. And today, he's the head of service, the man who mans the engine room of Abia State Civil Service. In Anambra, Charles Soludo did a similar thing, appointed somebody from Isukwato, Abia State. I'm from Isukwato, by the way. He appointed somebody from my local government recently as Accountant General. You know, it's a very sensitive position, Accountant General of Anambra State. And the same person came to Anambra State many years ago as a student in Oko Polytechnics, finished, then served in the state and was returned in the service and has risen through the ranks. And today, he's the Accountant General of Anambra State. Also, another young person in Anambra from Osun State, who is a permanent secretary. These are progressive measures we should be taking to make sure that national unity is promoted, and not like what is happening in Lagos. The Igbo should go renaming name streets they were originally named there. Yesterday, I just saw that Zumbambadiwe has been renamed to Kinola, whatever. In this modern age, I expect that the federal government should, condemn in very strong terms and force Lagos State government to go back to that name, because that name has been there since independence. Ozumbambadiwe played prominent role in bringing independence to Nigeria that these people who are today in Lagos State, including Sanwo-Olu, is enjoying. So why would the name be removed from the national archives and the annals as those who made Nigeria possible for the younger generation?
As Nigerians strive for unity, the treatment of non-indigenes in public service remains a key test of that goal. Legal victories like Mrs. Anikwendu's offer hope, but also a reminder that equality under the law must become a lived reality for all Nigerians, regardless of where they come from. Sydney Okafor for Anchor News.